Okay, so good morning, and I guess I'm going to welcome myself to the ILS board. I was telling Patricia, sort of the greatest surprise I've had was that I have some responsibility for this board, which is great. It speaks to lots of the things that I've cared about for years and years and years, as Lenny can tell you. And it's great to be able to be with the ones of you I know and meet the ones of you I don't, and look forward to working with together with all of us for a long time. So straight to the agenda. First item is the approval of minutes from the April 14th board meeting.
So can I ask for a motion?
Yeah.
I'll make a motion that we accept the minutes.
Is there a second? Okay. All in favor?
Aye.
Opposed? None? Okay, those are approved. Next item is Mr. Phillips, who I understand has COVID, and distressingly has a terrible symptom from it, which is his inability to smell and taste coffee. Coffee. Which would set me back a really long time, so I feel great. But thank you, and
But you put a tie on his
Yeah,
jacket.
I know.
That's really impressive.
Well, thank you, Chief Judge and members of the board. This is the second time I've had COVID. The other time also happened immediately before a board meeting. I'm not ready to make any grand pronouncements about correlation and causation, but it's suspicious. Today I wanted to give an update to the board on the enacted state budget, which was passed in early May after our last board meeting in April. So we wanted to, again, provide the update on what the enacted state budget means for ILS. And this will provide some additional context for Patricia's discussion later in the agenda about the ILS aid to localities budget allocation. So as you can see from the chart at the top of the budget summary document that was circulated, ILS's budget really has two main components. State operations funding, which is the funding that supports the day-to-day operation of ILS, our employee salaries and fringe, office equipment and supplies, employee travel, etc. And then the aid to localities funding. And that's programmatic funding that flows through ILS to local governments. In our case, it's to the 57 counties and New York City. For the state operations budget, the fiscal year 2023-24 enacted budget essentially held ILS state operations funding flat, with an increase that was close to $16,000 over last year. And that's going to allow ILS to continue our office operations, including staffing the currently vacant positions that we have, which I'll discuss a little further in the agenda. And then for aid to localities, which as you can see makes up the vast majority of ILS's all funds budget, the final enacted budget for fiscal year 2023-24 is an increase of $102 million over last year's final enacted budget, a substantial amount that's largely attributable to reasons that I'll explain in a few moments. The aid to localities budget bill breaks out ILS's aid to localities funding into several programs. Through this prior fiscal year, we had 4 distinct aid to localities programs, and this year's final enacted budget adds a 5th. To just quickly touch on 3 of the 5 aid to localities programs, all of which, as expected and as we requested, remain consistent with last year's enacted budget. The ILS distributions and grants remained at $81 million, as it has for many years now. Implementation of the Harrell Herring settlement remained at $23.8 million, as it has for many years now. And for the second year in a row, the extension of the Harrell Herring reform statewide is at the full $250 million. 4th program, Article 18B Family Court Representation Parental Defense, is a relatively new program. It's only a few years old. The ILS budget request that was approved by the board last September sought a total of $28 million for this program, which would have been an increase of $23.5 million over last year's enacted budget of $4.5 million. I think as the board is very much aware, ILS has consistently made the case publicly and privately about the need for more funding to support mandated parent representation. And the $28 million that we saw, while far from the true need statewide, would have allowed ILS to distribute funding to all 57 counties and New York City instead of dispersing the limited amount of funding we've received in prior budgets, as we have thus far via competitive RFPs, which so far have only been able to be awarded to less than half of the counties. While we did not receive that $28 million that we were seeking, the final enacted budget did include an increase of $10 million over the governor's executive budget proposal, for a total of $14.5 million for the program. You can see in the description of the program in the budget summary that $10 million of that $14.5 million of funding is coming out of the state's general fund, as opposed to the Indigent Legal Services Fund, which supports the vast majority of our office's state operations and aid to localities budget. That is an indication to us that the $10 million increase is what's known as a legislative add. In other words, funding that was added in by the state legislature during budget negotiations with the executive. And that's thanks to some of the strong committee chair support that we've been able to curry in the legislature, particularly Senators Hoylman Siegel, Bailey, and Brisport in the Senate, and Assembly members Dinowitz, Levine, and Hevesy in the Assembly. The ramification of the $10 million coming out of the general fund is that we don't really know at this point if we can count on that $10 million recurring in future budget years. And as a result, that will impact our plans for allocation of the $10 million, which Patricia will discuss further in the next agenda item. Since that's one of the big items, I want to pause there for a moment to see if there are any questions thus far. Okay, hearing none. I will go to the 5th Aid to Localities program, which is new this year. And it's related to a statutory change included in the state budget relating to increased assigned council rates. One of the policy bills included in the enacted budget amended County Law Section 722B to increase the statutory hourly rate that counties pay assigned counsel from the previous rates of $60 an hour for misdemeanors and $75 an hour for felonies, appeals, and family court matters, to a new rate of $158 an hour for all case types governed under Article 18B of the county law. And that's retroactive to April 1st of this year. That proposal also increased the statutory cap to $10,000 per case. It increased the case cap for experts from $1,000 to $3,000, and courts retained their ability to authorize exceeding either the hourly rate of the case cap, either the hourly rate or the case cap under extraordinary circumstances. As the board is aware, ILS has consistently advocated for an increase to the statutory assigned counsel rates, which were last increased in 2004. We've also consistently advocated that the state pay for the increase, recognizing that ultimately effectuating the right to counsel is a state responsibility, and out of a concern that, as in 2004, when the rates were last increased, counties may seek to absorb the cost of a rate increase by cutting back their spending on public defense in other areas. Changes that were made to County Law Article 18B in this year's state budget did not include an amendment to County Law Section 722E, which as a matter of law establishes that payment of assigned counsel is a county charge. However, the state budget did include this new ILS Aid to Localities program, which is entitled ACP Rate Increase, and it provides a $92 million appropriation, the purpose of which is to reimburse the counties in New York City for 50% of the eligible expenditures they incur as a result of the increased statutory rate. Notably, the appropriation language states that the $92 million is to be dispersed upon submission of a certification to ILS by the counties in New York City on a quarterly basis. The reason that's notable is because the vast majority of our aid to localities funding is currently dispersed via contract, which we identified early on as being an unwieldy and inflexible mechanism for dispersing this reimbursement funding for increased assigned counsel rates. There's several reasons for that, but chief among them is the unpredictability of any given county's assigned counsel rate expenditures in a given year. So we think this certification model for disbursement of the funding is a good opportunity to develop as simple and streamlined a process as possible to ensure we can provide timely reimbursement to the counties for their increased expenditures. And making that process as simple and streamlined as possible is also important because under the terms of the appropriation language for the $92 million, localities are required to submit claims for each fiscal quarter no later than 12 months following the end of that respective fiscal quarter. So we have developed a draft certification form for the counties in New York City to use to claim reimbursement under this appropriation. We're currently working with a number of state stakeholders, including the governor's public safety team, the Division of Budget, the Office of General Services Business Services Center, and the Office of State Comptroller to ensure that what we've developed will be sufficient for simple claiming and disbursement of the funds. So we intend to disseminate a final form hopefully later this month so that localities are able to start claiming for expenditures incurred in the current fiscal quarter shortly after it ends on June 30th. And I just have one final note about this new program. The $92 million appropriation is coming out of the state's general fund rather than the Indigent Legal Services Fund. However, the enacted state budget also authorizes the state budget director to transfer $114 million from the Indigent Legal Services Fund to the general fund. Our understanding from conversations with DOB is that the authorized transfer of $114 million covers this $92 million appropriation, as well as $22 million to support increased expenditures incurred by the judiciary for a similar hourly rate increase for attorneys for the child. So that's the budget overview, and I will open it up for any questions.
As far as the increase rate for assigned counsel, and I apologize if you covered this, but the county pays for that increase? It's a big issue in Western New York, but is it county funded?
So ultimately, the county pays initially the increased rate of $158 per hour. There's an appropriation included in ILS's budget for reimbursing counties for 50% of the cost of that increase.
So the local assigned counsel program has to submit or ask for the 50% reimbursement.
That's correct.
Thank you. Thank you.
Can I ask a question? How long will that last? Is it just for this year or just for the first 6 months? What is it?
So the appropriation for the $92 million, because this is an appropriation for fiscal year 2023, 2024, is for the period of time between April 1st, 2023 and the end of this current fiscal year in March 31st, 2024. So it's just for this period of time. And we will see then what would happen in the next budget cycle.
Just to follow up on that, we continue to be committed to, stating what Bert said we've been stating all along, which is that the state should be paying for the increase. And so we're continuing to convey that message with the board's blessing on that.
Has anyone done any analysis to estimate whether or not the 92 approximates half of the increased cost, or in the sense of whether it's enough to cover the 50%?
Yes,
Okay.
yes, and yes.
Okay.
So that's a really good question. It's we had been providing, the governor's office and legislatures with information about estimates of what we estimated the cost the state would be for a rate increase. And this is about half of what we had estimated.
Okay.
But as Burton said, it's hard to know because, the nature of assigned counsel work and vouchering is that it ebbs and flows.
Right.
Burton and Patricia, so we hope that since this was enacted for a year, that it will continue. That's our hope.
Yes.
Yes.
Okay.
Is it fair to say it would be sort of politically difficult to reverse that,
We hope so.
right? I mean, yeah, I mean, we're going to keep pushing for a greater percentage, I assume, right?
What we had been advocating for was an amendment to County Law 722E. County Law 722E currently provides presumptively that the county pays for all mandated representation. Now, it carved out exceptions for, implementation of the statewide plans, so the 250 million. And we had also advocated for an amendment to 722E to carve out an exception for the assigned council increase. Our view had always been that ultimately it's the state's obligation to ensure the delivery of mandated representation. And that for the state to pay for just a part of it and the counties to continue to pay for a part of it is more than reasonable.
Did you have to negotiate to reach that amount?
The 92 million.
Yeah. Were they willing to have a heavy prodding?
Yeah, no, I mean, we know from the governor's proposed budget, that proposed budget had the rate increase with no state contribution,
Oh.
right? So the counties were gonna bear the entire burden. And then the one house bills, meaning this budget bills proposed by the Assembly and the Senate, correct me if I'm wrong, Burton, but they both had the increase with the state paying for the full increase, if I remember correctly.
Believe the Senate one house proposal had a split, but the
That's right.
Assembly was the full.
Yeah, thank you. Yeah, so this was a compromise.
So maybe we'll get that posted next year.
Well, the lawyers will be very happy for the year, very happy. They've been waiting a long time. It's good news.
Yeah, it's good. It's definitely good news that the rates have been increased. And I think that it's our job to make sure that the counties are able to claim their state reimbursement efficiently. And to, generate and help, people who make decisions understand why it's important for the state to continue to pay for at least part of the increase.
So previously, the counties have been paying 100%. So,
Yeah.
so what's the net difference to them now? Is it basically static, or are they paying a little bit more than they were?
So Burton, do you have the form in front of you? It's on our certificate.
I don't, but I mean, I think we're expecting in total across the state, there will be an increased cost of about $92 million to the counties in New York City.
Right, so they're paying the base plus half of the increase.
Say that again?
Yeah.
Right.
So the 92 is not half of the total. It's not half of 158 times the number of hours. The 92 is half of the increase.
Correct.
So they're going to keep paying what they were paying before, and they're going to have, roughly equal amount to what the state's bringing out.
Right.
Okay.
Right. So the way we calculate it is that the state would be paying for misdemeanors about 31% of the cost, and for all other types of cases, about 26% of the cost.
That's family cases too.
Yes.
And what happens? Does it moot out the lawsuits? Because there are a couple of pending lawsuits moved out, or? Because the lawsuits, I think, want more.
Yeah, and I'm not sure about that, and I think that's a good question. My understanding is that the lawsuits are continuing. The one lawsuit we're most aware of course, is the Harrell Hearing Settlement Enforcement Action, and I'll talk about that at the end of the meeting. But the plaintiff's view is that the rate increase does not move that out. Now I don't know, litigation is litigation, so.
Right, exactly.
So it sounds like though, then the impact on the county is going to be different depending on their reliance on assigned counsel versus institutional providers, right? So there's going to be an uneven impact across the state. Are there places that you guys are worried about?
That's true. Yeah. So for example, some of our larger counties, and Sheila knows, Erie County, their primary provider is an assigned counsel program. So that will have a significant fiscal impact for Erie County.
Yeah.
I have a much more trivial question, which is what were you going to do with the $450,000 for state operations that you didn't get?
We had requested 3 additional positions. One was a human resource manager. Right now, our human resources function is hosted by OGS, and it's very cumbersome. And also, we think not sufficiently attentive to, we don't have that in-house consultation services that I think most organizations would want to have. We had also asked for an additional audit position, auditor for our grants unit, which would allow us to work to streamline our claim process, but have a back end process to really ensure fiscal accountability, which is what we're still pursuing anyway, but we still want to bolster our audit function. And then the third position that we had asked for was a position to bolster both our appellate representation services and our family court representation services. It would be a mixed appellate family court attorney. In other words, an appellate attorney with expertise in family court appeals. And this position was to work in our statewide appellate support center to be able to be attentive, not just to criminal appeals, but to family court appeals. And so, so those were the three positions that we had asked for.
We'll try again, Lisa.
Let's give up. To be honest, and Burton will touch upon this towards the end of this meeting. We have a lot of vacant positions that we are working to fill. And so in some ways, a pause for this year is acceptable, but it won't be acceptable next year. So.
Anything else? Okay, thank you, Burton.
Thank you, Burton. Thank you. So the next part of the meeting is an agenda item that will require a vote. And this is the board's decision regarding our proposed allocation of the 2023-24 ILS H localities budget. So the budget that Burton just reviewed. And as Burton said, our H localities budget essentially funds 5 programs. But within those 5 programs, there are a total of 7 funding categories. And so as I go through this, I'll talk about the 7 funding categories within each of those, in the context of those 5 programs. The first ILS H localities program is the program that has endured the longest and that has been with us since 2011. And that is what is called the ILS program. That is the $81 million that has been in the H localities budget now for, I think, about 9 years. That program has 3 funding categories. The first is $40 million made to New York City via the state finance law, section 98B, subdivision 3C. That's a statutory requirement that Burton and I sign off on every March. And so that payment is made every March. The second funding category within the ILS program is the ILS competitive or non-competitive distributions. And so since 2011, ILS has been dispersing this funding to each county via cost reimbursement contracts. And every calendar year, each county has 3 distribution contracts, which the annual amount of each contract when combined is the amount that that the county was receiving from the ILS fund as of 2010. So we disperse the funding in a way that keeps them whole, that keeps the counties whole. To receive an ILS approved contract for this funding, each county sends ILS a proposal explaining how they're going to use the funding, what they're going to use it on, how it will improve the quality of representation and supplement county funding, not supplant county funding. And our proposal has to show that the providers had a meaningful and significant role in developing the proposal. In other words, it was important to us to elevate the voices of the providers. So currently we are on this current fiscal year, our most recent distribution is 13. And so 30.2 million of the 81 million will be used to continue distribution 12, the 30 year of distribution 12, the second year of distribution 13, and then a new distribution 14, which will continue distribution 11. So the contracts build on each other. So that's the second funding category within the 81 million. And then the third funding category within the 81 million is 10.8 million for ILS competitive grants. Now, this is a relatively small amount of money that funds a lot of things. This funding has jump-started our council at first appearance programs in counties. It has jump-started funding for counties to reduce caseloads and develop quality initiatives. So our Upstate Quality Improvement and Caseload Reduction Grant. It funds our statewide network of regional immigration support centers. So we have 6 centers currently running that support attorneys in being able to adequately and sufficiently and accurately advise their clients on the immigration consequences of their criminal justice and family court involvement, and where appropriate, use those consequences to try to achieve better case outcomes for the client. And it has allowed us to fund model family representation offices in 2 counties, currently Westchester County and Monroe County. For fiscal year 23-24, this appropriation is needed to continue 3 of these grants. The first is our CAFA grant, our Council at First Appearance grant, which is now in its 4th iteration. So this will fund CAFA 4. The second is the Upstate Quality Quality Improvement and Caseload Reduction Grant, which is also in its 4th iteration. And then the third is the Regional Immigration Support Center. And so that's in its 3rd iteration. So that's what that funding is needed for. So that's the $81 million, which is a pot of funding, one program within our aid to localities budget that funds several different things. The next is the Harrell Herring settlement funding, which is $23.8 million. And as people, the board members remember, when ILS accepted the responsibility in 2014 of implementing the settlement, we essentially accepted the responsibility of working with the 5 settlement counties and their providers on developing plans for caseload relief, quality improvement, and ensuring that every person is represented at their first criminal court appearance. It took us a couple of years to fully develop those plans and to issue caseload standards, which was part of the requirement for caseload relief. But by December 2016, we knew that it would cost the state $23.8 million per year to fully fund the settlement. And so since the 2019-20 budget year and on, the state has fully funded the settlement at $23.8 million. So that's what that funding is for.
And the same amount every year.
Same amount every year, which is
No
a precursor to our September meeting. So,
Inflation.
yeah. No, and I think that's an important question because that's true for the 81 million, which has been the same. Yeah, the 23.8 million, and it's going to weave into the 250 million. And so, that will be part of our proposal to the board for our coming, when the board has to consider our budget request for fiscal year 24-25. So, I'm glad that we're already open to that. So, and then the fourth funding or third funding category or program in that aid to localities budget is Burton mentioned, is the statewide implementation of the settlement. And as you may remember, again, when legislation was enacted, extending the settlement initiative statewide, ILS was required to, by December of 2017, develop a plan for how we would do that and the amount of state funding that would be needed to have caseload standard compliance, counsel at arraignment, and quality initiatives throughout the entire state. And so we submitted that report to DOB, Division of Budget, in December of 2017, and we estimated at that time the cost to the state of $250 million. pursuant to the legislation, the state had 5 years to ramp up to achieve that full 250 million. And they did, the full 250 million was achieved in the 22-23 fiscal year. And so this is the second year of that full funding for statewide implementation. And then the last program in the ILS budget is the Article 18B Family Court Representation. And this, of course, is representation for parents in family court matters who can't afford to retain counsel. And, you know, we, as you know, for the past several years, this board has endorsed ILS's request for additional state funding to improve the quality of representation in family court matters, fully recognizing that the quality of representation right now is in crisis because of insufficient resources and lack of funding, and because the counties bear a significant, you know, they bear almost all of the costs for family court representation. In fiscal year 21-22, the ILS H localities budget appropriated 2.5 million for improved quality representation of parents in family court matters. And ILS used that money, dispersed it via our first family defense grant RFP. So it's a competitive grant, small amounts of funding. And that grant was $166,000 per year over 3 years. And so the idea was, you know, we could, you know, we did the RFP. We had over 20 counties submit proposals. We could only issue awards to 5 counties. So that's our first family defense grant. And then the following fiscal year, last fiscal year, 22-23, our H localities budget for family court was 4.5 million. So again, we used that to issue another RFP, the second family defense grant. And this time we were able to issue awards of 250,000 per year to 17 counties. So, you know, so right now there is approximately 20 counties receiving this funding. We requested the 28 million because we were hoping to disperse funding, to have enough to disperse to counties without having to make counties compete for something that's so important. But unfortunately, we didn't get the full 28 million. We did get 14.5 million. Yeah, it's a $10 million increase. And so, you know, we're happy that we got an increase. But while the 10 million isn't, you know, while the 14.5 is a 10 million increase over last year, and while that's good news, the good news has to be tempered with some realities. And one of them Burton touched upon, which is the fact that because it's a legislative ad, we don't know if it will continue in the future, right? It does signal that the legislature is starting to see this issue and understand its import. So that's a good sign. And so we need to make sure it continues and more into the future.
That's the question. Who determines the eligibility of the families, financial eligibility? Is it a standard?
So
300% of the poverty level or something like that?
Yeah.
Who determines?
So ILS has issued standards, and then more recently, but listen, I don't know if you want to touch upon this, but OCA did incorporate those standards into rules, court rules for courts to follow in determining eligibilities.
So it's OCA who determines it?
Well, so the individual judges.
Judges, yeah, some judges do ask providers to do screening and make a recommendation as to eligibility. I think that's done more in criminal matters than in family court matters. In criminal matters, most of the judges across the state ask providers to screen and make a recommendation. Family court, it's not as much.
So they're going to take anybody who says they can't, they don't do screening, they just give it to them, assign an attorney?
No,
Lenny's nodding, so he probably knows the practice, but.
We were cheating, we were
the judge-
writing notes.
The judge.
Yeah.
Yeah.
You know, they'll ask for information and make a determination. You rarely see it challenged. So, you know, if somebody's determined to need counsel, not being paid for, I've never seen it.
So, you know, second, reality of the 10 million, the additional 10 million is it's not enough to disperse funding to all the counties. So we have to do a competitive process again. So with the 14.5 million all told, there's again, a small amount, relatively small amount of funding that we need to do a lot with. And so the first thing we need to do is fund the second year of the second Family Defense Grant that we issued last year. The other thing we need to do is we need to continue the first Family Defense Grant when that funding runs out from fiscal year 21-22. And we would continue that again through an RFP, but this time we would raise the amount to $250,000 a year to align it with the second Family Defense Grant. And then the third thing we need to do is we want to continue the second model family representation office, the one that's currently in Monroe County. And so we need the funding to do that. And so we would, use some of this funding to continue that model family representation office. Again, that office, the funding was dispersed to be a competitive grant. So we'd have to do a competitive process again. And then the final thing we'd like to do is issue an RFP for a third Family Defense Grant. And this again would be much like the second Family Defense Grant, $250,000 per year over 3 years, or a contract total of $750,000. And again, it would be competitive. Counties would have to need to compete to obtain that funding.
I remember when that grant first came out, and a lot of the counties did not apply for it. Has that changed? Are people, the counties now more interested?
So we've done, so you're talking about the model family office.
Right.
Yes. So the model family office, we've done 3 rounds of competition for that. And each time we've gotten about 10 to 15 applications. Now that's to establish a model family representation office. So it's a lot more funding, as you know, than our family defense grants. And it does require counties to agree to pre-petition or investigation stage representation. And so the last time we issued that RFP, there were more counties applying. And so we anticipated we issue it again, there will be more counties. For the family defense grants, the upstate family defense grants, because it's not as much funding, we essentially say to the counties, send us a proposal, but the proposal, can do different things. It can provide for investigation stage representation. It can decrease caseloads. It can build quality initiatives, introducing a multidisciplinary approach of representation for family court matters. It can do one of those 3, or it can do a combination of them. And most of the grant recipients have done a combination of those 3 things. So that's our proposed allocation of the 2023-24 ILS aid to localities appropriation. Are there any other questions about it? This is a little.
Well, the allocations are fine. I'm trying to understand this need to do competitive bidding, right? Which I understand, maybe because of regulations, but you have some number of offices that already get funding, right? And have, I guess, strengthened their parental representation as a result of that funding. Is there, just practically speaking, do they get some advantage because now they already have the capacity, and so that's something that gets scored in a particular way? So, are they privileged to some extent?
No,
By the evaluation rubric?
I think that's true. I think part of the problem with the competitive process is more sophisticated providers and more sophisticated counties can do a better proposal.
Right.
So there is some unfairness to it. So I think, the chief judge and I had a preliminary conversation about this. What we really need is funding for all the counties.
Right.
And what we really need is a number of what it would cost to do in family court, what we're doing in criminal court.
And so Chief Administrative Judge a couple of weeks ago wrote to the chairs of both judiciary committees and copies of his counsel a fairly elaborate letter saying, we need more family courts in trouble. We need more family judges. We also very much need better funding for providers. And I was pushing very hard to understand the data behind it. And I'm not sure that we have very solid data. It turned out that the number of judges we requested was it was limited by physical constraints. That is, we believe we needed many more judges, but the most that we could fit in existing physical plant statewide was 27. And then the request also contained calculation of about $35 million of funding for providers. So, and the methodology there was to bring them to parity essentially with criminal caseload caps. I'm a little more confident in that number than I was I think we had a number ranged from something like 96 to 120 additional family court judges that we needed, which seemed not tenable to me. We didn't end up mentioning that number, we just said 27 physical capacity, but I think it would be very useful both for OCA and ILS to be on the same page about the number that's needed to bring the providers up to parity, and for the board here and for OCA jointly to push for that funding.
If the board supports it, what we could do, and I've talked to our research director, Melissa Mackey, about this, is do over the summer a combined feasibility and data collection survey of all the family court, the providers of parent representation in family court matters in New York. And basically what we would be asking them is, can you give us information about your caseloads in 2022 by petition type? Because that's how ILS has developed our caseload standards for family court representation. And if you can't give us caseloads for 2022 by petition type, could you give us the caseload information you can and tell us what it is, so we at least know what we're getting? And we think that with that, we would be able to come up with a good number, a very reliable number of what it would cost to do in family court family court representation, what we've been doing in criminal court.
So OCA does not presently track petitions by classification?
OCA does track petitions by classification, but we don't know of those petitions how many of them were assigned versus retained. And so we think though, by getting some information from the providers,
Right.
as well as some information from OCA.
Combine
Exactly, yeah. So if this board supports us doing that survey, I think we can accomplish.
I think it would be very important.
And you can do it. You have facilities to do it.
We think so. I mean, a lot of it depends on what we know we can do it.
Responses.
Yeah, it'll be, I think it'll be important for us to see what the providers can deliver to us. But if they know that this is for the purpose of, advocating for state funding needed to do what in family court, what we're doing in criminal court, I think, yeah.
And I think to get the funding, it's going to be important to have a defensible methodology.
Yeah.
Transparent. We're very comfortable with it. I mean, I think that my sense is the legislature is willing to fund things if we can prove the need and we can demonstrate what the result will be. The governor's office is a little more cautious, just for budgetary reasons, but I think we can get there if we make a good case.
Do we have an increase in judges?
We have a bill pending. We'll see if we get it now or later. If we do get it now, judges will be in their spots. The spots will be basically filled in the 2024 election. So we wouldn't really have the judges till the beginning of 25.
That's outside of New York City. The New York City judges get appointed.
They are appointed.
Funds.
Yeah, and the request from New York City is relatively, I think it's 5 of the 27. So the bulk of them will be coming until later, which is a disadvantage in some ways, but it's an advantage in other ways in that you don't need some of that funding until you have the additional judges. So it allows, we've been told by the governor's offices, there's some prospect of getting the judges, the legislation to the judges now, but the window on the budget is closed for this budget cycle, so it have to be next year's budget cycle. But that may all mesh better than we thought. But it does mean the summertime is when we've got to focus on this.
So what happens upstate when you have three hatters? Judges who sit as county court judges, servants, and family.
So in the places where I have a list somewhere of the counties where we've asked to begin with additional judges. Sometimes it's one, sometimes upstate. Sometimes it's one, sometimes it's two. In a lot of those places, it would then shift that work to a dedicated family judge. Yeah, yes.
The last program that, is included in our, request or proposed allocation for the 18 localities is, of course, the 22 million for the assigned counsel program. So that would be allowing us to disperse via the certification process that Burton talked about, the funding to counties to reimburse them for half the costs of the increase for assigned counsel fees. So that's the whole proposed allocation of the 23-24 ILS 8 localities appropriation. I don't know if anybody has any other questions before there's a vote.
No, I guess we need a motion. Second,
Second.
all in favor?
Aye.
Okay, it's unanimous.
Great, thank you. And thank you for the board support of the work that we'll do this summer to get good information from providers of family court representation.
Nora, we're up to you.
So, I think as this board knows, in addition to accepting the responsibility to implement the terms of the preliminary settlement, that meant also that our office grew with that responsibility, right? So initially, back in, I guess it was 2015, we started with the preliminary settlement team. Which was, I was a part of, Tricia was a part of. And we had 4 attorneys and a chief attorney, as well as legal and 2 researchers. And we began to work with the 5 counties as a part of the preliminary settlement team. Then, of course, with the enactment of the amendment to Executive Law 832-4 to expand the settlement to the rest of the state, we grew again as an office, and we created the statewide implementation team, which substantially mirrored the settlement team in terms of its makeup, right? So then they were devoted to implementing or creating plans and then ultimately implementing the terms of the settlement in the rest of the 57 counties. So both teams over the years have really been operating on these sort of parallel tracks to create these plans, to work collaboratively with the providers, to figure out, how best to allocate the funds within their budgets to meet the goals of the Executive Law 832-4 and the settlement. The settlement team has been working with counties to go a little farther ahead, right? Because of the nature of the way the settlement implementation began and ultimately has been executed. But at the end of the day, they were doing substantially the same work. We were all doing the same work, just at different stages of the process. So we've always sort of known that at some point it made sense to think internally about what would reorganization look like internally to make this a more effective team and a more effective process internally and for the county's work. So really as early as 2020, I began having conversations with the former statewide chief implementation attorney, Joanne McCree, about what types of steps we could be taking to join the work of our 2 teams and really collaborate internally to best support the providers. So we began with some joint projects. I think a very successful and ongoing project was our assigned counsel program summits, where we bring together the leaders of the assigned counsel programs. It was initially supposed to be in person statewide, but then we had a pandemic. And so we had to shift to a virtual model. But we had a series of those. I think the board has heard about those in the past. But we had a series of those meetings with the various chiefs over time. And I'm happy to report we actually had a wonderfully successful in-person summit with the leaders this past March. It's great to actually bring everyone together in person. So that was really fantastic. And that was really a joint effort of the settlement team and the statewide implementation team. And ultimately, it ended up being a joint effort of many others in the office as well, because we had the participation of the Family Representation Unit, some from the Statewide Appellate Support Center, and of course, our research is sort of underlying everything we do. And so it's been really a great thing, but we also had efforts with bringing Gideon's Promise to New York as a joint effort, and various efforts between the two teams about, figuring out projects for access to counsel, increasing access to counsel. And so, we kind of began with some of that and started to integrate the work a little bit more in that way. And then ultimately, last year, we realized that the timing was going to work out sort of very well in terms of our need to integrate our function internally with the way that sort of everything was timed out with the reforms. Because, as Patricia mentioned, the 5-year phase-in for the statewide, sort of the full 5-year phase-in was timed to about March 2023. And the settlement, after it was extended a year, is scheduled to conclude in September of 2023. It's the date here. And so ultimately, we're kind of falling into the same general timeline. So it worked out very well in that respect. So Patricia and Burton and Matt Alpern, who was former interim chief, and Melissa Mackey, our director of research, and I all began to have serious talks about what it would look like to integrate the two teams. We met and we came up with a lot of different ideas and a lot of different models, and we sought the input of course, the teams themselves. And we ended up landing on this model, which I think is reflected in the materials that we provided ahead of time. But essentially where we organized and integrated into one team, but we're organizing our work regionally. Taking a regional approach, I think, is going to be really helpful in the sense that one, it is certainly lessening the workload of the statewide implementation attorneys. So it's our own internal caseload relief. And two, it is, I think, an opportunity for people to really learn about sort of the counties and the neighboring counties and think about different initiatives that might allow them to work together, or things that are working in one county that might be similar that will help aid, another county in their successful implementation. So we're really excited about that piece of it. And then the other piece, of course, is that we created these 2 deputy positions to sort of split up and oversee the work. We named the deputies in March, I believe. And so that's Jennifer Chanou and Claire Zartarian, who were both team attorneys prior to the deputy announcement. And then, we began to assign the attorneys to the regions, and we sort of moved to this model in, I guess it was late March. So it's already underway, and it has been, I think so far, so good. The attorneys are beginning to really dig in and learn their regions. As you can see, we're divided into 8 regions. The deputies kind of oversee 3 to 4 each, and then the 8th region will be Region H, will be primarily focused on by the Western New York Regional Center. We're kind of moving into this new phase with statewide implementation now that we have, the year 5 full plan sort of in place to figure out, okay, this is what we're going to do. This is how we're going to use the money. This is how we're going to achieve the goals of Executive Law 832.4. So now this is really, I like to say this is where the rubber hits the road, right? And it's really making sure that it's successful, right? And that there's a way to ensure that there's successful implementation. And we saw this in the settlement counties, but obviously, it's a broader scale on the statewide. And I think by having this sort of internal organization, it's going to allow us to really support the counties. It's going to help us be better organized internally, and really critically, support their works and ensure the success of implementation. So that's where we are at this point. The other piece I just wanted to mention is that we're still working very collaboratively with the research unit. And we are, in fact, they participate in our biweekly meetings. And, I think that's such a critical and essential part of the work that we do at ILS. And it's what makes our work so effective, is that we have these varying perspectives. And so, we're working very closely to ensure the two teams are really as well. So that's the news in terms of the criminal defense representation team.
And so that's the beginning of office, better office integration. And I know when I interviewed with the board, one of the things I promised the board was that that would be a priority for me. And it's tricky because you want people to feel like they own their space and they know what they're doing, but you also want them to see the big picture and feel like they're part of that too. And so what we're really trying to do is create a combination of structures and an intentionality of communication, so that people can, across the office, know what's going on office-wide, feel a part of it, but still feel, a sense of responsibility for their particular role in the office. I think one of the areas I'd like to focus, we'll continue to focus on integrating the family court part of this, the statewide appellate support center, the research, but also the grants unit, because so much of what happens at the front end with the contracts and the back end with the claims is really important, valuable information. And so we'll continue this work. This is really a first really critically important step.
So geographically, where are these two people? Are they in your Albany office or are they?
Yeah, everybody's currently housed in the Albany office except for the regional support center in Western New York, or Western New York Regional Support Center. That's the one part of the structure that will be located in the region.
I should say, I think it says east and west on the deputy chiefs, but I think those are a bit of a misnomer because it's really east and central. And west is really going to be Western New York Regional Support Center.
Thank you.
Thank you.
It goes back to Burton for other updates.
Thank you. I think I mentioned every meeting, this is probably my favorite agenda item because it gives us the opportunity to demonstrate the continued growth and advancement of the ILS office. However, because there's really kind of a shorter than usual gap between the April and June board meetings, it's a shorter than usual rundown, but we have several updates nonetheless. Since the last board meeting in April, we've had 2 new ILS employees come on board. One of them is Rachel Rubitsky, our new Assistant Manager of Information Services. She's coming to us at ILS from the Capital Region BOCES, where she last served as a Senior Network and Systems Technician. She's got a master's degree in cybersecurity that we're hoping she'll never have to lean on in her role at ILS, but just in case, we've got her. And she's quickly getting up to speed with our longtime Manager of Information Services, Peter Avery, on the office's growing IT needs. So we're very happy to have her on board. We're also very happy to have Kim Martell, our new grants administrator. She comes to ILS from the Boys and Girls Clubs of the capital area, where she served as Director of Business Development and Grants. She has a wealth of experience on the provider side of grant funding, and we really welcome that experience and perspective on our grants team. We've got several incoming employees with start dates over the next couple months. I'll talk about them in more depth at the September board meeting, but the 2 employees that we have coming on board between now and then are Kingston Ferrati, who's going to be an investigator with our Statewide Appellate Support Center. He is starting later this month. And Elizabeth Isaacs, an appellate attorney with the Statewide Appellate Support Center. She's got a start date that is penciled in for August. Several positions where we have made offers and have accepted offers from candidates are still going through the budget director approval or BDA process. So we're not ready to announce them yet, but we will be in the very near future and are very excited and impressed with this slate of candidates. For our attorney in charge of the Western New York Regional Support Center, a special assistant with our statewide appellate support center, our family court program associate, and then backfilling our data outreach officer position. And then we are still actively recruiting for several open positions, all of which are currently posted on the state jobs website. 3 attorney positions in our Western New York Regional Support Center. It's a criminal defense attorney, an appellate attorney, and a family court attorney. We have 2 open positions on Nora's team, criminal defense representation attorneys that will be working in Region A, which is New York City and Suffolk and Nassau counties. And to the point, this is an Albany-based position, but they will be responsible for working with the providers and localities in that region. And then an open position for Region G, which is centered on Monroe County and sort of the Finger Lakes region. We also have 3 grants unit positions that we are posting for, grants manager 1, a grants manager 2, and a contract manager position. So hoping to have updates on all of those at our next meeting.
Questions? Thank you, and we're back to you again.
All right. So as a, as a state agency, we monitor constantly for changes to state law and executive orders that impact the operation of the ILS office and the ILS board. And there was a recent change to the executive law that we wanted to make the board aware of. Earlier this year, the governor signed into law a bill that places new requirements on state boards, including the ILS board, relating to their official websites. I believe Patricia has shared with you a list of the requirements for those websites. And to the extent they're applicable, these changes or this information needs to be on a website for the ILS board by November 1st of this year. I'll quickly go over the requirements, and I should note that the ILS board currently has a page on the ILS office website, and that page already fulfills several of the listed requirements here. To the extent folks have questions on any of the other requirements, we will answer them if we have the answers, and if there are any we don't yet have the answers to, we'd be happy to follow up and report back to the board on that. So I'll do just a quick rundown. Subdivision A, the statutory language, executive order, other legal basis for the establishment of the board. That is already on the ILS board's page. Subdivision B is public information, including departmental affiliation, contact address, phone number, and website. The affiliation with the ILS office is already clear on the board's website, and it also includes ILS contact information, which we believe fulfills that requirement. Subdivision C is a brief description of the purpose of the board and its legally required duties, including required reports and other products. The ILS board page currently links to that information. We will explore putting it more directly on the website prior to November. Subdivision D is the size of the board membership, current member names, other qualifications. That is already on the ILS board page. Subdivision E, whether members of the board are eligible for payment of expenses or other compensation in the performance of duties. And information on compensation and expenses incurred in prior and current fiscal years, as well as projected costs. The information about compensation is currently linked on the ILS board page, but again, we'll explore putting that more directly on the site. The board is compensated for its actual and necessary expenses. That is information we don't currently have on the board, so we're going to need to explore how best to include that information, including the projected costs. Subdivision F, the meeting minutes and agendas, dates and locations of meetings held and to be held within 6 months, or the location, including another website where the information can be accessed. That is information we do currently include on the ILS board page. Subdivision G is geographic and other relevant qualifications of all current members of the board, including the county in which the member resides and the background or expertise the members possess, where such background or expertise is required for membership on the board. There are no required geographic qualifications for members of the ILS board, but we do already list the statutory qualifications that board members must have. And we will explore more clearly noting which board members fulfill the relevant statutory appointment qualifications. And subdivision H is a catch-all, any other information the commissioner may require, and it also makes clear that to the extent geographic information has to be reported, nothing here would authorize the release or publication of any board member's address. To date, there's been no further guidance from the commissioner on additional information that would be required, but we will notify the board if any further developments are issued.
Now, unless our holdovers, is that gonna impact the information that goes on?
That's a good question. I'm not sure, and we'd be happy to look into that.
I think all of us. have some.
Yes.
Yeah. Yeah.
Just come on.
Yeah, I don't think it should, but we'll.
Okay. If no other questions, I'll turn it back to the Chief Judge.
I guess if there's people who are holdovers, should we fix that? Right, I mean,
Bring it to the new governor.
Or ask the nominating, or ask the nominating authorities to renominate.
Yeah.
yeah, I mean, we have to go, I guess it's a vacancy, but we
Right.
have to press the government about, you might as well.
By Shelley Silver, that was a long time ago.
I don't disagree with that. I tend to think that our priority right now has to be filling the vacancy by John Jones.
Right.
And then also, Zach is interested in somebody to replace. So I think once those are done, we can press again. Off the top of your head, if the board member terms are ever, I should be.
10 years. And
I've never been really. Gotcha.
Sorry. Patricia, could you repeat that?
The, under executive law 833, what are the board member terms?
3 years,
3 years.
August 1st to July 31st.
So I'm like, what's time?
Yeah. The question when you talk about holdover is like, how many of us have not been reappointed and we're therefore holding the seats pending reappointment, and whether or not there's been any real attention to that whole matter. I don't remember even what entity through which I got appointed. I think it was the state bar, but
Yeah.
you know,
Yeah.
It hasn't been an appetite. I mean, I was nominated by Shelley Silver.
Right.
Necessarily confirmed by, Andy Cuomo.
The board before you.
Right.
Yeah.
Yeah.
You didn't know, it was forever.
Your lifespan.
You vote and everything.
No.
Anybody to,
Yeah.
But I understand Patricia, the meeting.
Yeah, yeah, I understand.
Have we had 2 vacancies
Yeah.
now?
Yeah, two.
No, you're.
Last item.
The last item hopefully will be brief. I've spoken before at board meetings about the Harrell Henry Settlement Enforcement Action, which was initiated because of the assigned council rates not having increased since 2004. And it was creating problems with caseload standard compliance and quality improvement initiatives. More recently, we discovered council at arraignment in all 5 of the 7 counties. And so there was, we've been reporting to the parties about these issues in 2021, 22. Yeah, sorry. The plaintiffs finally filed, a notice which triggered a negotiation period, which fell apart by the end of last summer. And so in December, the plaintiffs filed a lawsuit in Albany County for Supreme Court, essentially saying that the assigned council rates need to be increased and the state needs to pay it pursuant to the terms of the settlement. That action is still pending. It's a little bit on hold because there was some discussion over scheduling discovery in that action. And more recently, the judge issued a letter to the parties, basically saying he wants a status report.
Trial level.
Yes, it's still, it's still pending, but there hasn't been any significant action in the past month or so while they're working out the scheduling order. And then simultaneously, in the meantime, under our obligations pursuant to the settlement, we have been monitoring the caseloads in Schuyler County. And we've noticed, at first what we thought might just be a short-term anomaly has turned into a long-term persistent problem. And that is with the public defender office having caseloads out, too many cases essentially. And so we've notified the parties of this and that we believe that the settlement would require an additional attorney for the Schuyler County Public Defender Office. And so the plaintiff has sent a notification to the state regarding that issue as well. And so that's pending. So those are updates right now on what is going on with the settlement enforcement action. Yes, that was one of them. And then there's also,
That's also one in New York City.
right, and then there's a statewide one that was filed by the New York State County Bar Association. So to my knowledge, none of them have been rooted out because of the rate increase, but I don't know. I don't know what information.
And none of them are at his level, right? Court of Appeals, yeah.
No, but no, they're all in the trial. Yeah.
So anybody, anything else? I think we're done. We're adjourned.
I make a motion that we adjourn.
Okay,
And our lunches are here.
so we're adjourned. Thank you.
Aye.
Thank you.
Thank you.
Thank you.
Thank you.
September 22nd.
What is it?
The next board meeting.